the current administration is characterizing trade and tariff compliance as a national security issue. From its perspective, the administration is intent on rebuilding the U.S. economy by protecting U.S. industries from unfair trade practices. This is not a policy issue. This is really a crusade to elevate the U.S. economy. Whether it will work or not, we will see. But this administration is using every lever they can find to increase American manufacturing at the expense of foreign trading partners. So U.S. corporations should be mindful of this new policy dimension and setup of expectations.
Global companies face unprecedented risks and challenges in today's economy. To mitigate these legal and economic risks, companies are rapidly embracing and elevating the importance of robust ethics and compliance programs to promote positive corporate citizenship. On Corruption, Crime, and Compliance, you'll hear from industry leaders and insiders about how to create effective ethics and compliance programs that will mitigate risks and maximize financial performance. Here's your host, Michael Volkov.
Welcome, everyone. Michael Volkov here for another episode of Corruption, Crime, and Compliance. And here we've got today an interesting and new development. Well, not a new development, but one that should be interesting to follow. And that is the Justice Department's use of False Claims Act to tariff and trade violation cases. So never underestimate the creativity and ability of federal prosecutors to take federal criminal laws to address new crimes or new enforcement programs. Corporate leaders and compliance officials are making a serious mistake when they confuse a pause in FCPA enforcement to mean a reduction in overall federal criminal prosecutions of corporations. This administration has no problem in taking aggressive positions in the legal arena, and I would expect them to do so at DOJ in prosecuting federal criminal offenses. DOJ's pronouncements make it clear. Aggressive tariff and trade enforcement is coming. DOJ officials have made it doubly clear that this will happen along with supporting comments from regulatory agencies responsible for overseeing the complex maze of trade laws and regulations. In response, companies have to take immediate action and shore up their trade compliance programs, especially those that depend on trade with China and hot-button countries. Those that assume that they will get off with at most a slap on the wrist are in for a serious surprise. Now, why do I use the alarmist language? I don't normally use it, but I want to be clear with everyone that the current administration is characterizing trade and tariff compliance as a national security issue. From its perspective, the administration is intent on rebuilding the U.S. economy by protecting U.S. industries from unfair trade practices. This is not a policy issue. This is really a crusade to elevate the U.S. economy. Whether it will work or not, we will see. But this administration is using every lever they can find to increase American manufacturing at the expense of foreign trading partners. So U.S. corporations should be mindful of this new policy dimension and setup of expectations. Circumvention of tariffs, avoidance of fees, and compliance with national security requirements in the trading arena is imperative. Companies do not want to be the poster child for trade abuse or fraud at the expense of domestic industries and workers. So the Trump administration is gearing up for the real fight. The new corporate enforcement program is aimed right at trade compliance and corporate trade practices. DOJ's whistleblower program now includes rewards for tariff, trade, and customs fraud or circumvention. Under the radar, though, and for the last few years, what I expect this to increase significantly, DOJ intends to pursue False Claims Act cases built on trade violation predicates. This development is a logical next step, but it carries significant risks and penalties for companies. The Trump administration already has emphasized the importance of False Claims Act cases to reinforce government efficiency mandates and to protect taxpayers against fraud. It is not a big leap to extend these initiatives into trade compliance. By bringing the False Claims Act to a complex set of laws and regulations governing trade, companies that depend on trade on the supply side will face a new set of significant risks, one where whistleblowers, documentation, and aggressive enforcement will require careful mitigation and responses. Now, DOJ has made it clear that the use of the False Claims Act will include these tariff and trade violations. And let's go back to February. The Assistant Deputy Attorney General, Michael Granston, the DAG, warned that DOJ intends to use the False Claim Act to pursue illegal trade practices. In addition, DAG Granston noted that the False Claim Act will be used as an important tool also to push government efficiency and root out waste, fraud, and abuse. Other DOJ officials have reinforced this message and noted a key area of enforcement will be customs and tariff cases where the actors misrepresent the origin of the products, the declared value, and or the number of goods involved in the source, obviously. DOJ officials often cite as an example the 2023 case against International Vitamin Corporation, which we're going to talk about, which resulted, or they're seeking at least a $22.8 million settlement. Going forward, companies should expect civil and criminal cases against importers and customs brokers who engage in smuggling or misrepresent key details in documentation to evade fees and tariffs. Over the last 5 years, FCPA enforcement involving trade violations has increased, but with this new administration's focus on trade issues, this is going to increase exponentially. In 2020, Lind settled FCPA claims for $22 million for misclassification and undervaluation of imports. In 2023, International Vitamins Corporation resolved a similar case for $22.8 million, as noted above. Now, the False Claims Act broadly prescribes making false claims to a government entity, like the Customs and Border Protection Agency, CPB. The FCPA incorporates the concept of reverse false claims, which applies to tariffs, import fees, and other trade costs. In addition, the FCPA incorporates misclassification of products under the Harmonized Tariff Schedule, HTS. Companies that report products under the wrong HTS can create FCPA liability when it's an attempt to seek to reduce otherwise applicable duties. A third common risk area is false claims surrounding country of origin as a means to lower import fees or avoid tariffs. Each of these three areas present FCPA liability risks. Companies have to ensure that trade compliance and financial controls work together to mitigate risks in these areas. Let's take a look at some of the recent cases. On April 18, 2025, Barco Uniforms, the U.S. filed a complaint against Barco, which is operated and controlled by Kenny Chan and David Chan, and it's a Chinese company, alleging that they violated the FCPA by knowingly and improperly underpaying customs duty owed on imported apparel. Barco sells apparel, including uniforms, to restaurants and healthcare providers, among others, and they operate various companies that supply Barco with apparel manufactured overseas, including from China. The U.S.'s complaint alleges that the defendants conspired to avoid or decrease the payment of customs duties by undervaluing imported garments they purchased from foreign suppliers. The government's complaint alleges that the defendants used a double invoicing scheme featuring false entry summaries presented to CPB that undervalued imported goods purchased by Barco. And they engaged in efforts to cover up the conspiracy even after the DOJ served CIDs, civil investigative demands, on the entities and intentionally omitted Barco's name from Form 7501 entry summaries involving products imported by the supplier companies from China. Now, that case is just pending. But here's some resolution cases. The Yogobu case, that's a great name, Yogibo, was a failure to pay duties. In July 2023, DOJ settled an FCPA case against Yogobu, a furniture seller, which agreed to pay $217,000 to resolve allegations that it violated the False Claims Act by failing to pay customs duties on imports from China. Between 2016 and 22, Yogobu imported goods from a Chinese manufacturer, Leader Show. For each shipment, Leader Show provided Yogobu with two invoices, a commercial invoice listing one price for the goods being imported, and a second invoice, which it called the QC invoice, that included a separate and additional charge for inland freight to a Chinese port design services, and quality control testing. They did not provide the QC invoice to its customs broker for determining the duties, and instead only provided the commercial invoice with the lower total price. The customs broker then did not calculate the correct duties owed based on the total cost of the goods. And in this case, the customs broker did not appear to know nor to participate in the scheme. But the settlement stemmed from allegations originally brought in a lawsuit by a whistleblower. The second case that I want to look at is International Vitamins, the misclassification case in which International Vitamins, and I mentioned this above, settled FCA claims for $22 million for submission of over 1,000 CPB Form 7501 through its customs brokers that contain false information concerning the classification under the HTS of certain products consisting of raw and bulk vitamins and nutritional supplements imported into the U.S. from China. IVC discovered the misclassification and retained a consultant in the fall of 2018 and provided the correct classification. Notwithstanding this correction, however, IVC continued to use the incorrect codes until September 2019 and never reconciled the years of underpayments. And a final case I want to look at is Danco. Danco Laboratories agreed to pay $765,000 to resolve allegations that it violated the False Claims Act by failing to pay certain customs duties, known as marking duties, which are on imported pharmaceutical products that lacked markings to identify their country of origin. The Tariff Act of 1930 requires companies that import foreign products into the U.S. to mark the country of origin on those products. Importers that fail to mark their products are subject to a 10% ad valorem duty. The settlement resolves allegations that during the period 2011 to 2019, Danco failed to mark imported pharmaceutical products with the appropriate country of origin and thereafter violated the False Claims Act by avoiding the marking duties owed to the United States for those imports. Again, reverse claims. So those are what we're looking at in terms of False Claims Act cases, and whistleblowers are going to be looking for these cases, particularly with the new tariffs coming into force. So this is something that we're going to look at again. In another episode, we're going to talk about customs compliance and making sure you don't get caught in any of these types of situations. Thanks again, everybody. We'll see you next week. Have a terrific week for another episode.
If you enjoyed this episode, the best way to support the show is by subscribing on your favorite listening platform. To learn more and connect with Michael Volkov, go to volkovlaw.com.